God save the United States and this honorable court. Case number 21-7006, Gregory Smith, appellant versus District of Columbia et al. Mr. Klaproth for the appellant, Mr. Fatat for the appellees.
Good morning, counsel. Mr. Klaproth, you can proceed when you're ready.
Good morning. May it please the court, my name is Brendan Klaproth. I represent the plaintiff appellant Gregory Smith. This is a civil rights case brought by Mr. Smith under Section 1983 in connection with an unlawful over-detention by the District of Columbia. On March 18th, 2014, a judge in the DC Superior Court ordered that Mr. Smith be released from custody of the Department of Corrections. Rather than release Mr. Smith from custody as ordered, the Department of Corrections detained Mr. Smith for 23 days. The cause of Mr. Smith's over-detention was a computerized system used by the Department of Corrections called My Justice. And the problem with My Justice is that it had a 1 to 2 day delay in the system.
Let me ask you, Mr. Klaproth, are you not relying on the failure of the order that was accompanying the marshal and Mr. Smith to be uploaded into TMS? Is that not part of your case?
It's not, and the reason why is to go back a little bit. During the course of discovery in this case, we requested TMS data for that order, which was not produced, and this resulted in a sanction to the District of Columbia. So we never received the data regarding the TMS. One other point about the TMS system is that the Rule 30.
Well, you do. I'm sorry, but you do know that the order. I know there was a failure to produce it, and there was wrong-headed briefing on the summary judgment on the premise that the order didn't exist, and then the district ultimately found the order. But ultimately, as I gather, that order was logged into the system at 9:30 p.m. So you're not relying on that delay or the fact that, so if Mr. Jones was checking the system at whatever it was, 6 p.m. and that order didn't show up until 9:30 p.m., that's not part of your case at this point. You're focusing on the My Justice gap.
That's correct, because when Mr. So just as a point of clarity, as far as we know, it could be an error from discovery that information relating to that order was never uploaded at all into the TMS system. But what's at issue here is the fact that Mr. Jones processed the one order at approximately 6 o'clock, as Your Honor indicated. And as part of processing that, he was required then to check the My Justice system to see if there was any other detainers or orders that have been released in related cases. And the problem is that there was a 1 to 2 day delay in the My Justice system. So Jack Jones testified at trial and also in deposition.
I thought that the inherent delay was an hour, 1 hour delay. And then there have been instances where there's been a delay of 2 days.
That's correct. So in Exhibit P6, which was the policy statement for the Department of Corrections regarding releases, it indicates that there is a 1 to 2 day delay. And one of the witnesses did say that it was frequently an hour or so.
The court didn't credit that apparently, because the finding, I believe, is that it was ordinarily, there's inherently a 1 hour delay. And of course, you have these instances in the past where not 23 days, but 2 days have passed. That is not detained.
Yes, and so the District of Columbia knew that, though, and they memorialized that in their policy statement and document. And unfortunately, in this case, when Mr. Jones checked the release, which was issued earlier that day, around 1:30 or 1:24, actually, I think, and then when he went to process the release at 6 o'clock, he testified that the order was not in the system.
I thought he testified that if the order had been in the system, he would have seen it, but he didn't have any actual recollection of that day and that order.
So he did testify that quite explicitly during trial that when he looked at the system, it was not in the order. The order was not in the system. And so, and that's the evidence we have. And had the order been in the system, and he even testified that he checks the very closely because it's important. Had the order been in the system, he would have processed the release, and Mr. Smith would have gone home. And so that is the causation of Mr. Smith's over-detention. And the issue we had, here the court found that there was a constitutional violation. The court found that plaintiff proved the existence of a custom. The court found, however, that plaintiff failed to prove that the My Justice system was the cause of his over-detention. And the issue, the court misapplied the law when it came to causation. Specifically, the court erred by requiring that plaintiff prove a pattern of prior constitutional violations caused by the My Justice system. And this is just not required. Essentially, that is the test for deliberate indifference under Baker's fourth prong, not the third prong where we were proceeding at trial.
I agree that the district judge's holding is a little bit confusing on this point, but she does clearly state the standard, and I think correctly state the standard around JA 543 to 544. She says, did the plaintiff also need to show deliberate indifference? Under prong 3, all you have to prove is the policy is the cause. Official knowledge of existence of the practice, not knowledge of the results. In other words, not knowledge that there were a lot of similar over-detentions in the past and deliberate indifference to that pattern. So she seems to get that right. And then she says deliberate indifference is about the failure to train prong. So it is a little confusing why she then later focuses on the lack of a pattern. But do you agree that at least at that stage, she's correctly stating the distinction between the need for deliberate indifference on an omission case under Baker prong 4, but that it isn't needed on a custom or practice claim under prong 3?
So yes, that's what's interesting about this case, because the District of Columbia was arguing throughout trial and even here on appeal that under the third prong, you have to prove deliberate indifference, right? And so the district court did clarify, it was clear and correct in its articulation of the law, saying we did not need to prove deliberate indifference. However, in practice, in the application of the actual law to the facts of this case, the district court did on JA 552 and again on JA 564 go through and fault the plaintiff for not proving a pattern of prior constitutional over-detentions, and that's where the district court's decision ultimately came down.
But she makes a sort of a series of alternative holdings. And at the end of the day, why isn't plaintiff's exhibit 14 fatal to your case?
Exhibit 14 being the over-detention reports, I believe?
No, exhibit 14 is the My Justice printout. And as the district judge points out, both orders appear there. And I think at trial, she said it wasn't clear when that order was added to My Justice. But then later in her ultimate conclusions of law, in an alternative holding, she seems to say that because both orders, the order from the 2012 case and the order from the 2014 case, both show up there with timestamps, and I'm looking, I think, at 559 of the JA, that is fatal to the case.
And I see the amount of time, but if I can answer your honors.
Certainly, if you can continue, our practice is that we'll use whatever time we need to ask questions and to give you a chance to answer them.
Thank you, Your Honor. And so with respect to, I think the best analogy to use for My Justice and court view dichotomy is it's almost like Pacer and Pacer Monitor. All right, so we have court view, which is Pacer, and it's uploading information immediately. And then you have this secondary system, which pulls the data later in the day. And so obviously when we printed out, we received in discovery during the course of litigation, the complete record from My Justice. It contains the release order and reflects that it was received at approximately 1:24 by the Department of Corrections. However, Jack Jones testified. We showed him that excerpt at trial, showed him that precise excerpt and said, was this information in the system when you looked at it? And he testified unequivocally, no, it was not. And
What
so
page is that, Mr. Claproth?
for Jack Jones's testimony,
Yeah.
So that would be JA 405 through 407 and 413.
405 to 07. And where's the specific passage that you're describing?
So line 13 on 405.
Okay, now what you looked at, when you looked at My Justice for Mr. Smith on March 18, 2014, did you see that he had been ordered released? No. If we could you turn the exhibit 14 on, please? Okay, the court. And how do you know now that you didn't see it then? That's the court. And the witness says, this is just from general experience of working through justice. When you look, you read everything carefully just to make sure, and you double check before you finish completing the process in justice just to make sure. And I would have noticed it and caught it right my second look. He never testified that it was there, that it was not there, because he couldn't possibly recall that particular date in his work routine. And I'm quite sure that the findings of fact specifically at some point make clear that the judge is rejecting that and your claim that Mr. Jones testified to that effect and saying in fact that he testified as we just heard. Now, am I wrong about the finding of the court? Where is it?
Well, if we also then look at JA 407, line 2, question reads, okay, it then reads, defendant is released in further status is set at defendant's request. Did I read that correctly? Yes. Question, to be clear, you did not see that entry on March 18th, 2014 when you were processing the release in the 2014 case. Is that correct? That's correct.
And I don't believe it was credited because the prior testimony was only that would have been the general practice. So where in the findings do you have anything supportive of this?
So, well, I mean, there's also evidence during his deposition, which was questioned when he was questioned by
findings of the court, not the input, but the output.
This is the evidence we have, though. So
I understand that, but when there's contrary evidence or the evidence is insufficient in the court's view, that it's in the record is no longer material. The question is, what were the findings and were they clearly erroneous?
So, well, with respect to this, though, we have 2 to 3 instances. There's no contradictory evidence and there's no disputed fact. And so, I mean,
the contradictory evidence is out of the mouth of Mr. Jones. First, that would have been, he would have seen it if it were there. And then 2 pages later, yes, to the question, did you see it? I mean, it wasn't there. And he says, that's correct. You just pointed it to us, 407, right? Which is contradictory to 405.
Well, I think 405 is providing context about his general practice. I don't think it's contradictory. And during his deposition, the District of Columbia's lawyer questioned him. Was this information there? No. And then she followed up and asked, well, because, can you explain why? And then he explained the delay in the system, how sometimes the system is not accurate. So that's the evidence. There's nothing to the contrary to suggest that, what I think an important point here too is that the Rule 30b-6 witness for the District of Columbia testified that all staff members complied and processed the order pursuant to the District of Columbia's policies and practices. So this isn't a case of staff error where we're trying to hold the District of Columbia liable for under a respondeat superior case. This is a case about the failure of the process, not a failure by the person. And I see I'm well beyond my time. So if the court has any other questions, I'm happy to address those. Otherwise, I'll yield my time to my colleague.
Do my colleagues have further questions? We'll give you a couple of minutes. Oh, I'm sorry. Go ahead, Judge
Come
Ginsburg.
back in rebuttal on the findings, if I could trace this down further.
So we'll give you some time on rebuttal, Mr. Klaproth.
Okay, thank you.
Thank you. And now we'll hear from Mr. Is it Patak?
Patek.
Patak.
Patek, hard P, yes.
right.
Thank you, Judge Pillard.
Great. Thank you.
And may it please the court, Ashwin Patek for the District of Columbia. This case concerns Mr. Smith's wrongful over-detention in the DC jail for
We know what it
22
concerns.
days.
Let's go to the argument. We know what it concerns. You've heard what we're talking about.
Yes, Your Honor. And I think there are two primary reasons why his municipal liability claim, which is the only claim that's up on appeal, fails. The first is that he did not prove that the policies he suggests were lacking were the cause and fact of his over-detention. And second, whether framed as a knowing failure to act, foreseeability, or deliberate indifference, Mr. Smith did not prove that the district should have known the policies he challenges would result in the error that led to his over-detention. And I'm happy to address each in turn. I think the most important being that Mr. Smith simply did not prove cause and fact at trial.
Mr. Patak, is there any dispute that Mr. Smith would have been released had the release order in the 2012 case been seen and acted on as a result of Mr. Johnson's check of the My Justice database?
I don't think there's any dispute about that. Of course, if the Department of Corrections knew that a release order existed, no matter how they found out about the release order, they of course would have processed the release order because nobody wants a person who's supposed to be released to be released. But
I'm a little puzzled by the district court's references to My Justice as not a system they relied on for release. That may be true, but I don't think, and I don't take you to be arguing that that defeats causation here. The fact that it was a further step, that they should have had the order in hand in both the 2014 case and the 2012 case. And it was a bit of a fortuity that Mr. Jones was checking My Justice at all. But given that he was, if Mr. Klaproth had proved that the time delay was a cause here, then you would have to agree that would be sufficient.
Well, so I just want to be clear about the timeline here. What we know is that the practice. So Mr. Jones gets the 2014 order, and everybody agrees that process seems to have gone correctly. And at that time, he says that he must have checked My Justice, and he thinks apparently that My Justice didn't show a release order in the 2012 case. But what we don't, and that of course is a testimony that district court judge, did not really credit because it was based on a speculation about what he would have done. But what we don't know is that when the 2012 order came into the Department of Corrections, which everybody agrees that it did, whether or not the 2012 release order was also in My Justice at that time. And so
the 2012 order came into the Department of Corrections. I thought there's a timestamp that's 9:30 p.m.
There is, Your Honor.
Okay.
And so at that, in other words, everybody agrees that the 2012 order came into the Department of Corrections and then was not processed. And there just was not evidence about why it was not processed, but it wasn't not processed because of any failure in My Justice. And in fact,
that's the nub of it, isn't it? Go ahead.
I think you're right, but the truth of the matter is what may have been happening on My Justice at 6:30 that evening when the 2014 order was being processed isn't really what's at issue here. It's whether or not when the Department of Corrections should have processed the 2012 order, whether My Justice had anything to do with the failure to process it. And the district court judge found that it didn't. What the problem?
Wait, you're going to have to run that by me again. I'm not sure I follow.
The problem in this case is that everybody concedes that the 2012 order did show up at the Department of Corrections and was stamped at the records office. But then, for whatever reason, it wasn't processed. And that failure to process the 2012 order had nothing to do with My Justice. My Justice was a later step in the process.
So you're saying that even if it were proved decisively that the 2012 case order should have been promptly reflected in My Justice, but was not reflected until, let's say, midnight that night. And Mr. Jones was checking My Justice because he was processing the 2014 order. Are you now taking the position that the time delay in that scenario would not be a cause of Mr. Smith's overdetention, because it doesn't matter what My Justice showed when Mr. Jones was checking the 2014 order? All that would matter would be, were he checking it pursuant to the 2012 order, what it showed?
Yes, because the process of the processing a release order only happens when the Department of Corrections gets a release order. And in this case,
that's an extraordinary position. And this is the first time I've heard that position. The cross-check, I understand the district to require of My Justice is to see whether, when someone has a release order that's being processed, there are any other cases that require the individual to be held. And the only reason that he's held pursuant to the 2012 case is because on checking My Justice, I mean, again, this is, I understand that the district's position that this may not have been proved, but Mr. Klaproth's position is that on checking My Justice on the 2012 case, it erroneously failed to show that he had also been released on that case too. So I'm not really understanding your effort to somehow categorically render the status within My Justice of the 2012 case to be irrelevant unless and until it's being checked pursuant to a TMS or other verification of the 2012 case itself. But maybe I'm misunderstanding your new position.
well, I think the reason it's irrelevant, and I agree with Your Honor that we are also, of course, making the argument that the question of what was going on My Justice throughout that day has just not been proven adequately at trial. However, I think the reason that it is irrelevant is because even if they had gotten the 2012 order at 9:30 at night, and even at that time, for some reason, My Justice didn't reflect that same release order, the 2012 release order in the system, that, at that late time, still the release would have been processed, and the Department of Corrections records examiner would have simply contacted the court's quality assurance office and made sure that the release order was, in fact, legitimate. So the My Justice, sorry.
No, finish your thought.
The My Justice system was simply an effort to check whether there were any other cases that merited a person continuing to be, incarcerated. It was not the method by which release orders were transferred from the court to the Department of Corrections. The method by which release orders were transferred were either through the TMS system or on the last load envelope. And here, everybody agrees that the 2012 order was in the last load envelope and did arrive at the Department of Corrections.
Do they? I mean, I thought there was some confusion about exactly how it got, and that the district's position was that it's to this day not known actually how this order got to the Department of Corrections and was timestamped. And I think it's an inference you're drawing because of the time of day corresponds to a timely processing or timestamping after the last load. But I thought the district affirmatively said it did not know.
Fair enough. I think it's an inference based on the timestamp.
So I know this isn't the focus of Mr. Klaproth's claim, but is there any question that Mr. Smith would have been released had the Department of Corrections refused to retain him without a March 18th recommitment order? You know what I'm referring to? The district judge was quite interested in the fact that typically a prisoner return or another commitment order on the day that the person returns from court is needed, and that there wasn't one in this case. Had the district insisted on affirmative evidence that what the Superior Court judge intended was recommitment, that would have also triggered the quality assurance, at least investigation or some further steps, no?
I think that's probably right. Again, there is pretty scant evidence on that point, but I think that's probably a fair inference. But that, of course, is not the policy or custom that Mr. Smith is challenging in this case. He is not suggesting that there was some issue with those types of, recommitment orders. So that it, isn't the policy that's the suggested Monell violation here. But I agree with you that that does seem to have been, a failure here. There should have been that type of order to, incarcerate him once more.
And you're not standing on the notion that there is a requirement of deliberate indifference in a Baker prong 3 policy custom or practice case, are you?
So I think what I would say in response to that is I think there are different ways to formulate the test here. And I agree that in Baker, the court only used the words deliberate indifference when it was describing, so-called prong 4. But I think there is some level of culpability that a plaintiff does need to show in every municipal liability case. And the way that Baker framed it was a knowing failure to act. The way the district court framed it was foreseeability, which was an aspect of causation. But whatever it is, there does, I think, have to be some showing that the district was on notice about some prior pattern or reason to know that a particular policy would cause a constitutional violation.
Mr. Prior pattern, why? I'm not sure I follow that.
So I guess
if the policy says, let's say you had a policy where everyone knew that there was a 2-day delay in My Justice. And I mean, just for fun, let's say a day delay in TMS, and the instrument examiners were doing checks, sooner than that, and finding, inadequate information. You wouldn't need to have any proof of any prior practice. It just stands to reason this is the policy, and the policy caused this detention. No?
I think that is correct, but I think that is the very rare and extreme case where purely on the face of a policy that isn't itself unconstitutional, it will result in unconstitutional outcomes. There is no question, because it's built into the system, that you're going to have a 1 or 2 day delay, and there's no way to get around it. So I think
actually is Mr. Klaproth's case. I think he has this policy document that says, don't, beware when you look at My Justice, there's a 1 to 2 day delay, and then consistent testimony from Myrick and Brown and Jones saying, yeah, we saw that there was often a delay in My Justice. So it's not as stark facts, but I think that is the nature of his case. And if he could prove that, there's no need for any prior cases of this very dysfunction, is there?
Well,
just as a legal matter.
I think there is, and that's for a couple reasons. First of all, the way in which the Department of Corrections gets release orders here is not through My Justice. So the 1 to 2 delay in My Justice is not going to be the kind of situation where it's just obvious on the face of a policy that over detentions are going to occur. Release orders show up through TMS or through the last load envelope. And those happen every day. Multiple release orders every single day pass through that system. And there's no indication that it ever results in the situation which happened here, which is that an order shows up to the Department of Corrections in whatever way, is stamped by somebody in the records office, and then for some reason is not processed. And with regard to the My Justice 2 day delay, I think the other issue is there has been no case offered where that delay has caused an overdetention. It just before this case, there is no example of that. And so I think that is a problem with Mr. Smith's culpability, with the culpability aspect of his case. I think when the district is just not on notice that a particular policy is resulting in overdetentions, where the policy is not on its face obviously going to result in a constitutional violation, I think that is a problem.
So it requires that there be 2 parallel charges or 2 parallel cases being processed, because the only reason that Mr. Jones would have been checking My Justice at all, given the absence of the order hand delivery system working is because he did have the order in the 2014 case, right? So the category would be limited to such a situation in which you had two orders and somehow maybe they were mistaken as copies of the same order and not properly handled. But so we're limited to that category because otherwise, as you say, you wouldn't be looking in my justice. But in that category, is there not, on the face of it, this exact risk?
No.
Bracketing the question whether the proof shows it occurred here, seems to me that the district is a little bit on thin ice, because could one show causation? I don't see a problem with the municipality being responsible for this custom or practice.
No, Your Honor, because my justice was not what the district was relying on in order to timely process release orders.
No, but it was relying on it to determine whether somebody should still be held, and that was an error in this case.
Right, but the error was the result of not failing to process an order that did admittedly show up to the Department of Corrections. So
the error is the error in the late delivery of the order in the late hand delivery of the order in the or failure to process or whatever of the 2012 order is a rationale or a justification here, as opposed to a further problem that simply hasn't been the focus?
Well, it certainly was a problem, the failure to process.
Yes.
It also is I suppose a justification, it would be one word for it. In other words, it is the method by which orders are delivered and processed, not my justice. And so when something goes wrong, as it certainly did in this case, the reason something went wrong is because that process of transmitting the order went wrong, not because my justice had some sort of delay.
It's both. I mean, it could be both. And again, assuming that there's proof that the delay was the problem here. Those are equally causes, no?
Well, they're both but-for causes. I agree with that, but I don't think they're equally causes. I think only one is the actual proximate cause of what happened in this case, because it is the method by which DOC is receiving orders. If there are no further questions, we would ask that you affirm.
Thank you, Mr. Patak. Mr. Klaproth, you have 2 minutes for rebuttal.
So my colleague for the district really tried to drive home the point that my justice is not a method to receive release orders. But I think it's important to remind the court on summary judgment at docket entry 83, page 6 through 7, the district wrote, examiners are able to access release orders through an e-system known as My Justice, which provides access to the information contained in the Superior Court's e-system court view. Thus, misdemeanors are processed by a system that does not rely upon the transport of a paper order to the jail for processing. So there on summary judgment, the district is saying we're using My Justice and not relying on a paper system. So their position has changed here on appeal. And Mr. Jones' testimony at trial really drove home the point, the method of how to receive a release order through My Justice. And that's, you can download it directly, or you can call quality assurance at the court to have a copy faxed over.
What's the exhibit number, Mr. Klaproth?
I'm just referring to the summary judgment briefing that was in down below. And so, you can download it directly.
So tell us again exactly where you're looking. It's the district's summary judgment brief?
Yeah, it's docket entry 83.
Okay.
And it's at page 6 through 7 where they made that representation. And then again on Joint Appendix 400 to 401, where Mr. Jones describes the method of receiving a release order through My Justice. And that's downloading it directly through the My Justice system or calling quality assurance to receive a release order. And it was also not in dispute. In fact, the district even conceded at trial that it was appropriate to receive release orders through fax from quality assurance. Whereas here, they're stating on appeal, you can only receive them through TMS for the last load. Another point of clarification, just on the record, TMS, the Rule 30b-6 witness testified unequivocally that TMS is not a system to receive release orders, but instead a system to monitor staff. And the fact that there was a document in the queue, and I quote her, meant absolutely nothing to the corporate witness. And so that's what we were basing on. That was the evidence in the case. Counsel also referred to the language in Baker, knowing failure, to suggest that plaintiff needed to prove the existence of prior over detentions. That language in Baker is cites to the city of St. Louis v. Propotnick case, and that case by the Supreme Court has no mention or reference of a knowing failure or any sort of notice that is required, and that's Supreme Court precedent. So there is no requirement. There's a body of case law where there is such as the Connick case that does require a pattern of prior constitutional violations, but those are all deliberate indifference cases. Now, one of the cases cited by the District of Columbia for that to advance that argument is a custom case. They're all deliberate indifference cases, including Blue, as well as Connick.
Mr. Klaproth, if a custom is not facially unconstitutional, then what showing do you have to make, though, to show that the city is culpable for the constitutional violation? I mean, where a custom itself is not, unconstitutional.
So, well, County of Bryan, the Supreme Court case from 1997 tells us when you have a situation such as here where the policy or the custom itself violates the law, then issues of culpability and causation are straightforward. And so I think when it comes down to moving force and showing that there is causation, we just apply the causation test, which is substantial.
I think that, well, Judge Rao, you can follow up. I think you haven't quite answered her question.
Right. I mean, what is unlawful precisely about the custom here on its face? I mean, it may have, obviously, in your view, led to an unconstitutional result, but the policy itself is not unconstitutional, or the custom itself is not unconstitutional.
Well, and so I don't think it's necessary for us to prove that the custom itself is unconstitutional, that we prove that the custom or practice causes the constitutional violation.
But in those instances, don't you also need to somehow show culpability for the city?
Deliberate indifference, right?
Right.
And so, well, I'm sorry, I didn't hear Judge Ginsburg there.
It's deliberate indifference. Once you're in the world of the failure, it's not unconstitutional on its face, but it can produce these sport results. Then you need to show that the district was aware of it and was deliberately indifferent to it.
Yes, that's the test for the fourth prong, but here we're proceeding in the third prong. Which
right, and I think that the question is, does the custom or practice, if it is clearly the custom or practice of the municipality, and it causes the constitutional violation, is there any difference between the kind of causation or knowledge of the policy, of the practice that has to be shown between a practice that on its face is unconstitutional? We have a practice of hanging people up by their fingernails, or a practice that is not on its face unconstitutional, but that causes a constitutional violation. So, we rely on a database with a known, 8-hour delay. Sometimes we check it within the 8 hours. Sometimes we check it after. Is there a different standard of knowledge or culpability if the practice or custom is not manifestly on its own unconstitutional?
I don't think it is. And I think the distinction with the level of culpability that differs is when a plaintiff is trying to hold the municipality responsible for the actions of an employee, right? So like in deliberate indifference cases, you're trying to hold whether it is a failure to screen case, a failure to train case, where an individual then goes, an employee commits a tort or violates the constitutional rights of an individual, and the plaintiff comes in and tries to hold the municipality. So deliberate indifference has that higher culpability level to guard against instances of respondeat superior. And so here, though, that's not an issue. There is no risk of respondeat superior. There's no evidence that any individual did anything wrong in this case. We're trying to hold the district accountable for its own policy that resulted in this constitutional violation.
Mr. Klaproth, the district court, I won't say admonished, but pointed out that you, in your proposed findings of fact, were taking testimony out of context. And I think you did it again this morning in the opening part of your argument, saying that Mr. Jones checked and saw no relevant order on March 18, 2014, when the district court has made a finding that Jones has no present recollection of what my justice showed when he accessed it on March 18, 2014. I think you're going to have to be more careful going forward. That's advice, not a question.
If I can just respond briefly, the court then further states under finding of fact 59, Jones's testimony was less definitive. But when we looked at the joint appendix 407, my reading of it, it was quite definitive.
You're looking at testimony. I'm looking at the facts that were found by the court. Don't you understand that once those facts are found, unless you want to argue they're clearly erroneous, which you have not even suggested, those are the facts that we deal with. Not what's testified by one witness and not credited by the court. It's not that complicated, Mr. Klaproth.
Other questions?
Unless the court has any further questions, I'm happy to yield.
Thank you, counsel. Case is submitted.
Number 20-5365, William Turnbull et al. Appellants versus Kilolo Kijakazi in her official capacity as Acting Commissioner of the Social Security Administration and Social Security Administration. Mr. Bruce for the appellants, Ms. Soni for the appellees.
Morning.
Mr. Bruce, you may proceed when you're ready.
Thank you, Your Honor. Jonathan Bruce for the plaintiffs. May it please the court. Waiver of exhaustion in the DC Circuit is a disjunctive test requiring satisfaction of one of three prongs. In this case, all three prongs are satisfied. And the only other court to have considered the same issues, the Beeler case in the Seventh Circuit, the Beeler court found that all three prongs were satisfied. To go to futility first, the Beeler court found that this lawsuit targets a system-wide agency policy and practice that uniformly deviates from the governing law and does not depend on the particular facts of any individual case. This is precisely the type of lawsuit that should not be subjected to an exhaustion requirement.
Your futility and collaterality arguments are really one and the same, right? It's that your claim is a legal claim. It doesn't depend on specific facts as found by the agency, and therefore there's really no point in delaying and pushing the clients through the agency before deciding the issue.
Yes, Your Honor. In this case, definitely, I would agree with that. The collaterality and futility definitely overlap. Yes, ma'am.
Mr. Bruce, do you agree that the standard of review here that we have is abuse of discretion?
No,
To find a waiver?
no, Your Honor. The district court's decision it is not appropriate for that standard of review, but rather de novo. The plaintiffs clearly meet the textbook definition of futility. It is a challenge to a broad-based agency policy, resulting in an unlawful reduction. And it's a facial challenge to this broad policy, which is not bound up with an individual benefit determination as the
waiver question in particular, I'm thinking about potentially irreparable harm. I mean, under Avocados Plus, hasn't this court said that when we're looking at the non-jurisdictional aspect of the waiver issue, we do review the district court's decision under an abuse of discretion?
Your Honor, the plaintiff's position is that de novo is appropriate here. Certainly, when it comes to the abuse of discretion standard, that standard is also met in this case, and I'd be happy to explain why, Your Honor. Beginning.
Proceed under that standard of review. That would be helpful.
Certainly, Your Honor. The government attempts to distinguish from the Beeler decision, for example, by mentioning the fact that the Canadian pension at issue in the Beeler case is mentioned in the Palms policy manual and is partially subject to the windfall elimination provision and partially not. And it opposes to that the fact that there are pensions at issue in this case, which are not mentioned in the Palms, as if that were relevant or dispositive. It isn't. The only thing that matters is whether or not the plaintiffs are subjected to the unlawful reduction of their benefits. Everything that the government has said about two-tiered pension systems, voluntary contributions, totalized benefits, a 30-year exemption are all distractions and are irrelevant to whether or not the plaintiffs have been subjected to this policy. And they also require a presumption that the government is right on matters pertinent to their substantive merits. That is to say, the division of employment into what is covered or non-covered.
Mr. Bruce, on irreparable harm, and I understand it's your position that any one of the three grounds for waiver suffices, but on irreparable harm, it's your burden. And how could we know whether any of these plaintiffs are irreparably harmed by diminution of their Social Security benefits if we don't even know what their levels are, whether they're people who are really living hand to mouth or whether they're people really at the higher end who have a lot of means? I mean, that might make a difference on, at least on that element. And you're showing your proffered declarations are really quite scanty on those points.
Your Honor, this case involves senior citizens who by definition are living on a fixed income.
Well, no, many senior citizens are not by definition living on a fixed income. That's the problem. Is, as you know, in this country, people receive Social Security for their work, whether they're quite well to do or otherwise.
And whether they're still working.
Well, yes. But I meant by definition, I meant the fact that the income from their Social Security is fixed according to governmental standards. We respectfully bring the court's attention to the declarations in the record, indicating the very palpable harm that those plaintiffs have experienced, and also a principle which is well recognized that getting an unexpected reduction in those benefits, which the application of this provision presents to these plaintiffs, presents a special kind of irreparable harm or special kind of harm.
Mr. Bruce, do you agree that just generally, I mean, we don't have the merits before us, but just generally with the characterization in the government's brief at page 13 of generally the nature of your legal claims, what the nature of your claims is? And I know you objected to the amount of their briefing that focuses on the merits, but in order to pass on your collaterality ground for waiver, it does seem like we need to understand the nature of your claims and whether they are indeed, general facial challenges to the statute, or whether they're much more contextual and turn on the kinds of factual determinations that are for the agency to make in the first instance. So I just wonder, in terms of, for our purposes in applying the collateral analysis, whether you have any disputes with the way the government rather concisely characterizes the claims that you're raising.
Yes, Your Honor. The plaintiffs dispute that on two grounds. First is the relevance of those irrelevant criteria that the government evokes, which by definition are irrelevant.
I'm sorry, I think I wasn't clear in my question.
Yes.
Just to understand, that the way that the windfall elimination provision works is a little bit obscure.
Mhm.
And in order to understand your claims, whether they're categorical, facial, legal claims, it's helpful to have a little bit of a sense of what it is you're challenging.
Yes, Your Honor. What is
And I'm just wondering whether, if you turn to the red brief at page 13, there are 3 bullet points there that describe what the government, I think in quite good faith, is trying to characterize as your claims. And I just wonder if you think that's fair, and if not, how you would characterize your claims very succinctly for the court.
We characterize this claim as an attack on a single simple policy provision, Your Honor, which is applied to all plaintiffs and which is unlawful. The government, by contrast, has brought to the court's attention various contextualized agency policy criteria, which by definition do not pertain to any of these plaintiffs, as if to suggest that they are relevant. And beyond this,
I think you're fighting a softball, but it's your case.
Well, Your Honor, the plaintiffs do not, what I like to make clear is that the plaintiffs do not accept the government's characterization of this case in such a way that would argue that it is required for the application of irrelevant agency criteria to be necessary in order to effect an orderly agency process here. The plaintiffs are attacking a single provision applicable to all plaintiffs.
Are you arguing on the merits that the windfall elimination provision shouldn't apply because your client's foreign pension payments are not based on earnings alone, but are based on earnings for which there were also residency requirements? Isn't that part of your case? That the fact that there might be residency requirements on some of the work that your clients did abroad renders them not subject to the windfall elimination provision?
You know, we are arguing that their employment is deemed covered employment under the windfall elimination provision statute.
Right, under various theories, right?
No, on the plain language, Your Honor, of 415A7A, which requires that the service that is designated as employment in an international agreement, by definition, all of the plaintiff's employment has been designated as such in the international agreements. So the government's, it's my understanding, Your Honor, if I understand you correctly, I just want to respond to your question by pointing out that the government's invocation of these various irrelevant criteria, which present exemptions from the application of the windfall elimination provision, by definition, are not applicable in this case. And they require the presumption of the lawfulness of those irrelevant criteria, which is a merits position, which is not something which has been briefed yet, and is not something which is which an inappropriate presumption to make at this point. When one does not presume the lawfulness of the government's divisions into covered or non-covered employment, one cannot go ahead and simply just dismiss this case on the basis of a presumption that its merits are flawed.
To my colleagues have further questions?
Yes, Mr. Bruce. The elephant in the room is the government's argument that there's no venue here, that you don't have proper venue for 31, I think it is, of your 33 plaintiffs. A simple argument based on the straightforward reading of the venue provision. And as I recall, your responses to that all have to do with what would be good policy. Is that correct?
It certainly does include that, Your Honor. But in addition to that, we would point out that really the only that there is precedent in the Beeler case for establishing venue for those who are outside the jurisdiction. In the Beeler case, there was one plaintiff for whom venue was appropriate, the lead plaintiff, and others outside the jurisdiction were also included along with that plaintiff under the venue provision at 405G, and the government did not contest that at that time.
So it's your position that as a legal matter, venue only need be established for one plaintiff in order for venue to be appropriate, and your best case for that?
Our best case for that, is Jewish war veterans versus the United States, Your Honor. And we also point to Weber versus Norwalk and Califano versus Yamasaki. It is true that this court has not specifically addressed whether under 405G, if venue is proper for one, it's proper for all, but it has addressed whether that is the case under 1391. And 405G has the same statutory language, the plaintiff, which has been construed to mean a plaintiff, and to reach opposite conclusions on the basis of the same statutory language would violate principles of statutory construction, as well as those policy concerns that Judge Ginsburg mentioned.
So the Beeler case is on the Social Security Act, and the other cases you cited are on other venue provisions, correct?
Yes, sir.
And were those were all Supreme Court cases, I believe? Dealing with the statutes, or two of them anyway, I think. Is that correct?
Two of them, Your Honor. Yes, sir.
So I'm not sure why you think it's open to us to depart from the plain reading of the statute when the only counterindication, well, not the only, the principal counterindication is that the Seventh Circuit would disagree with that on this statute, and that the Supreme Court has broadened the reading of the venue provision on other statutes, but not this one. I mean, it might be a good argument for the Supreme Court, since they've been receptive in some of these other cases. But I don't see, I think it would take a bold circuit court, let's put it that way, to advance, to accept your position that the means A.
The District of Arizona, Your Honor.
Well, the Seventh Circuit tells us it's more important than the District of Arizona. I know that's is that whatever the case is, that's Fournier, I guess.
Yes, Your Honor.
Right, yeah, that one's right on point. And is that pending appeal?
I'm sorry, sir, could you repeat that?
Is that case pending appeal, or is that, oh no, it's long settled, sorry.
Yes, sir.
2009, okay.
Well, thank you. If there are no further questions at this point, I would rest.
All right, thank you. We'll give you a couple of minutes for rebuttal, and we'll hear now from Ms. Soni.
May it please the court, Sushma Soni, Department of Justice. I'd like to clarify one thing initially, which is that my opposing counsel's references to the Beeler decision that went in their favor were all district court decisions. And because the government won on the merits, none of those initial decisions like class certification or venue were decided. When plaintiff refers to what happened in Beeler was a class action, and the general rule in class actions is that only the named plaintiffs need established venue. So it isn't necessary.
And or exhaustion as well, right?
Yes. And
but they filed as a putative class action. So wasn't it error for the district court not to treat it as a class action unless and until he'd crossed that bridge and decided the class issue on its merits?
no, Your Honor. In this case, the plaintiffs did not, they styled it as a putative class action, but that has no legal consequences until they have actually, the district court has certified the class. Here, they never moved for class certification even after a year. In fact, when the court disposed of the government's dispositive motion, there was no pending motion for class certification. So in this case, it was irrelevant. They had to all establish venue. And venue
you refer to Beeler as sort of sweeping away what the district court decided on venue, but what about on exhaustion? I mean, Beeler really shows that the legal issues are facial and susceptible of decision without getting into the weeds of administrative processing on the claims. I mean, you don't think there was any error in the Seventh Circuit decision in Beeler, do you?
Your Honor, the district court was the one that decided on exhaustion. The Seventh Circuit never addressed it.
Right, but they didn't need to. I mean, that's my point. You don't. So first, you don't disagree with or find flawed any aspect of the Beeler decision by the Court of Appeals, do you?
Not by the Court of Appeals, but
Right.
the government did not challenge the exhaustion decision by the district court because we won on the merits.
Exactly. But if the merits is susceptible of accurate determination in the absence of exhaustion, the question is, why isn't the Beeler decision, Exhibit A, why these plaintiffs in this case should not be required to wait many more years and flounder through the administrative process without the guidance of a decision from our court akin to the guidance that the Beeler case offers in the Seventh Circuit?
I think the best way to answer Your Honor's question directly is to give a concrete example of what would have been the benefit for Mr. Pezos, one of the two individuals for whom venue was proper, if he had gone through the process. What kind of information could have been elicited that would have been helpful here? And I know that my opposing counsel says that this is all irrelevant and a distraction, and none of it applies to these plaintiffs. But you'll notice that both in their reply brief and on appeal, and here in court, he does not cite the record to support this assertion that it's all irrelevant, because there is nothing in the record for these individuals. So let's take Mr. Pezos as an example. He received an initial determination. That's it. All it says is how much money he is going to receive per month, that they took into account he worked an additional year, and that his payment is reduced because he is also receiving a pension that was based on work that was not covered by Social Security taxes. That's all it says. And then it has additional information about how to apply for Medicaid and other things like that. He then goes directly to district court. So what we have in the record is that one 4-page document for him. If he had gone through the process, the agency would have looked into what type of pension he received, because the initial determination doesn't even say that he's receiving a Greek pension. And as it turns out, there are several types of Greek Social Security payments, just as there are for other courts.
So they don't, just sketch for us where I thought the fleshing out of the facts and the close questioning that you refer to happens at the first stage. Is that wrong? Just if you would sketch for us the administrative process and when the details of what kind of pension is being received from abroad, and what's the nature of that work, and what are the terms of the totalization agreement with that country. That those fact-intensive determinations, they don't happen in the first stage?
No, Your Honor, that's the intake stage, where the individual meets usually with a representative and provides the information that they have. And there is close questioning at that point, but it continues throughout the process. So for instance, additional information is provided with the reconsideration decision. You can see some examples of that in the record for some of the.
So step one is the intake stage, and that's the stage that Mr. Pezos has gone through.
So the first step is, of course, presentment before the administrative process. The four-step administrative process starts with the initial determination, which Mr. Pezos received. And it had just the information that I listed to you. In fact, it's at, I believe, 215 of the joint appendix. So you can see it. So the next stage is if he had sought reconsideration, at that point you get, he could say, here are the reasons why I think that you were wrong. And the agency would then look closely at the information on his pension. What type of pension did he receive? They would look into whether it was in fact earnings-based, residence-based, citizenship-based, based on voluntary contributions or financial need or anything else, or some combination of those.
So the determination that's been made with respect to Mr. Pezos has not taken into account these basic things like what type of pension was it? Was it based on earnings or residence? None of that has been considered?
Not yet, because all he did apparently was say that he was receiving a pension that was not from non-covered employment. So then at that point, Your Honor, all this additional information comes in and he can request to go before an administrative law judge. As you know, the whole process is not.
That's the step two reconsideration. I just like a quick, if you could just quickly sketch for us. So step one is the intake stage. Step two, you said if he seeks reconsideration, then that goes to the ALJ?
So step one is initial determination.
Yeah.
Step two is the reconsideration decision, requesting reconsideration. Step three is the hearing before the administrative law judge and decision-making. And step four is review by the appeals council. And at every stage, there can be additional questioning and there will be additional investigation of what the evidence that the individual has put forward. They will check whether this was a payment that was pursuant to an international agreement. They will look into whether sometimes individuals, Mr. Pezos could say, for instance, I worked in Greece before there was an international agreement with Greece, and therefore I was subject to dual taxation. It's the kind of thing that can come out.
But none of that is looked into when the agency on its own makes the initial determination.
No, because for the international side, we are initially reliant upon information that the individual brings forward. Now, for the individual's covered employment within the United States, the agency does have a record. And that's also quite important because there are exceptions that apply. For instance, for an individual who has worked in 30 years of covered employment. So the agency would, if you look at some of these reconsideration decisions, you'll see reconsideration decision will typically have a listing of covered employment by year and the amount of the earnings. And so then you can see, did the individual work for 30 years, in which case they are exempt from the windfall provision. Or if not, this is typically where an individual can say, some of my years of earnings are missing. And there will be some back and forth because it is non-adversarial. They can say, I have payroll stubs that show that I actually did pay Social Security. I don't know why my employer didn't put this in. And there will be some back and forth. And it may be that the individual is entitled to a full exemption. Or if you worked between 20 and 30 years, you get a reduction in the effect of the windfall provision.
But none of this is actually slightly shocking to me, just to be candid, that given the fact that the information on the foreign income is not in US databases, at step one, when the determinations, the sort of raw determinations of benefits and the application of the windfall elimination provision is done, it's done in what is admittedly a very over-inclusive application. You just take all foreign income and assume that it's subject to the windfall elimination provision. And only if the individual seeks reconsideration and presents more granular information is that carved back to exclude things that would not cause the windfall and therefore aren't properly counted against the US pension. Is that right?
Yes, Your Honor, because you have to look at who has that information.
I understand that, but there's not the person has to take initiative. If they trust the government and think, the government's expert on this, I had foreign earnings and I had US earnings. And if it turns out that the foreign pension is not the kind that triggers the windfall elimination provision, the person is never the wiser that it's on them to raise that.
Your Honor, that's why this is the first step in the process.
Right, but the second step depends on someone objecting. Is that right? It's not something that the administration would take you through and say, here's a questionnaire, by the way, we don't have this information, you need to let us know these chapter and verse.
Your Honor, if you look at the initial determination, you will see that there it says, do you have any questions? If you want to appeal, it lays it out. The expectation is that this is the first step in the process with the individual. And so even if at the end of this entire process, the individual ends up with the same benefit, or maybe simply gets a little bit more, maybe the windfall provision is not completely removed, nonetheless, what you have at the end of that process is the agency had a chance to correct its errors. It had a chance to reconsider how it applies the provision. You end up with a reasoned and usually much more elaborate decision explaining why it applied the provision. And you have an administrative record, which you do not have for these two individuals, Mr. Pezos and Mr. Jones.
But why, again, I go back to the question I started with, which is, in Beeler, the general decisions about the law, about whether the definition of employment is consistent throughout, or is broader under what is it, 410 or 411. Those are high-level legal determinations that can be sorted out and made clear as they were in Beeler. And then the application of those, it would seem to me, would be much sort of surer if our circuit, like the Seventh Circuit, had a definitive legal ruling on the facial challenges. No, I'm just trying to sort of understand why your triumph in Beeler isn't making you want the same opportunity now rather than many years down the road. And I'm not persuaded yet, although I'm open to persuasion, that the details in the individual cases bear on those general legal questions. They certainly bear on the individual's takeaway at the end of the day, but does the answer to those questions as a statutory, regulatory, and policy matter turn on how it's going to affect the pensions of these people?
Your Honor, I'd start with the fact that this is a very different case with respect to the individual plaintiffs than Beeler. I don't believe any of the, if you look at Ms. Beeler herself, she went through, I believe, almost the entire process by the time she filed suit. And I believe she had exhausted remedies by the time it got to the question of class certification. Here, the only two individuals that we are concerned with, Mr. Jones and Mr. Pezos, took no further steps. And therefore, we have no information about whether the provision, whether there were reasons why this provision would not have applied. The plaintiff spends a lot of time saying that this is a blanket, one-size-fits-all application of the statute. And we spend the same amount of time saying, no, it is a highly individualized and very context-driven determination for each one of these plaintiffs. Now, that is why in virtually every other case challenging the windfall provision, and there have been cases in almost every circuit involving exceptions to the windfall provision, like the uniform services exception, which was recently heard in the Supreme Court. In all of those cases, these proceed as individual claims that go through the administrative process and then go to district court.
Ms. Soni, can I just ask you maybe a more legal question? So is it the Social Security Administration's consistent position that for waiver of exhaustion, you need that the three circumstances are disjunctive? Is that a consistent position that the government has taken in these cases?
Your Honor, the different circuits have different standards on this. So, for instance, in the Seventh Circuit, you had to show all three criteria were met, but they were satisfied under state law by a lesser showing than they are in this circuit. So we have to go by what the way that the circuits approach this.
Because that's an open question in our circuit, whether you need all three or just one. So if we were to find that one of the circumstances applied here for Mr. Jones or Mr. Pesos, then would we need to decide whether all three circumstances needed to be met? Would we need to reach that question?
It would depend on which of the factors you thought was met here. For instance,
why would that make a difference?
For instance, the only case I'm aware of, I believe it was Tataranowicz, in which the court suggested that perhaps you only needed to show one factor. That case involved futility, and the court expressly stated that the purposes of exhaustion would not be served by requiring the individual to go through the administrative process. And that's a question the Supreme Court has asked in cases like Matthew versus Eldridge or City of New York. Here you reach the opposite conclusion. You would say, here it would have been very helpful for the plaintiffs to go through that process because we would have a record. Instead, they went directly to district court with a record that for these two individuals, Mr. Jones and Mr. Pesos, consists of one 4-page initial determination for Mr. Pesos and nothing for Mr. Jones. And the district court is expected to evaluate the agency's decision-making in applying the windfall provision to these individuals with no reason, no explanation, and no record. That is
But
one
Ms.
reason why.
Stoney, one of the things the plaintiffs are challenging is the definition of employment under Section 410. Same issue that was one of the issues that was up before the Seventh Circuit in Beeler. There was no problem in that case of the district court and the Court of Appeals saying plaintiffs are wrong about their definition of employment under Section 410. And that's not going to be illuminated one way or the other by factual development. In fact, they have a class action, so we can be confident that some members of the class that it's a live dispute because some members of the class have employment that would be treated one way under their theory and a different way under the government's theory. So I guess I'm just not really understanding why this isn't collateral in the same way, because it's raising the same claims that were raised in Beeler.
So just to be clear, Your Honor, this is not a class action.
They're raising it as a class action.
Well,
Yeah.
but it is not a class action at this point.
Yeah.
It's just these individuals. So and now I've lost my train of thought. I apologize.
Just the question why it's not a collateral legal question.
Okay, it is no more collateral than, Your Honor, Heckler versus Ringer, where likewise the individual there said, I'm not challenging benefits. I have a pure legal question. It is whether, in fact, this surgery is necessary and appropriate. And what the Supreme Court said was that is, in essence, a claim for benefits. And here we can look directly at the plaintiff's complaint. What did they ask for? They asked for recalculation of their benefits and an award of back benefits. This is not related to a claim for benefits. This is a claim for benefits, and claims for benefits have to go through the administrative process. As the Supreme Court has said, this act channels virtually all legal challenges through the administrative process. And at the end of that, the agency gets a chance to refine the issues, maybe reduce the number of issues that go to the district court. And maybe the plaintiff actually, his claim is resolved. There have been, as the plaintiffs themselves pointed out to the district court several non-plaintiff individuals who prevailed during the administrative process and one plaintiff. So
And it's
it's
also, counsel, isn't also possible that the two persons here may, after full determination, not be entitled to any more money at all?
that is possible. That's always
Even
possible.
under their own theory.
Yeah.
Yes, Your Honor.
Yeah, we just don't know anything about them.
We know nothing about them. We know a very small amount from the complaint, but for instance, for Mr. Pezos, just getting back to him, neither the initial determination, because it never contains this kind of information, nor the complaint even says how many years he worked in the United States and how many years he worked in Greece. That information just isn't in the case. For Mr. Jones, we have no information in the administrative record because the plaintiff's counsel did not provide his social security number and the agency was unable to pull his records and compile them into the administrative record. And in fact, that was the case for several other plaintiffs as well, which is why their information is not in the administrative record.
If these claims are dismissed for want of venue or for want of exhaustion, presumably they could be refiled in the appropriate court after the requisite exhaustion work was completed.
It depends, Your Honor. If the district court had simply dismissed those 31 individuals for improper venue, that is usually a dismissal without prejudice, and the individuals are free to refile in the appropriate venue. Here, there was also a determination about exhaustion of remedies for Mr. Jones and Mr. Pezos, but the court dropped a footnote saying that its analysis on exhaustion also applied to all the other plaintiffs except Plaintiff Merkel, who never presented a claim. So it would depend on the preclusive effect of the different parts of the court's judgment.
Why would a failure to exhaust determination potentially be preclusive of an ability of that individual to go and then exhaust?
It might fall within a line of cases, Your Honor, where if the dismissal for improper venue is coupled with another disposition, that then it is treated as a dismissal with prejudice.
And are those cases you cited or that you can cite to us?
No, Your Honor, I don't have them with me when this is something I looked up after the briefing.
So what I'm concerned about, obviously, is if these plaintiffs are, sent back to the administrative process to work it through, especially given what you said about the initial intake stage and how incomplete that is, and how much the accuracy of the Social Security Administration's determinations of application of the windfall elimination provision depend on, the full process. These people are not just going to be precluded and or time barred by their participation in this case, are they?
So for some of them, there will be timeliness issues. I mean, I believe Mr. Lunt, his initial determination was in 2004. So that was a considerable amount of time before they filed suit in 2016. Other individuals actually were much like Mr. Pezos himself, were received determinations in 2016. It was he was actually within 60 days of the filing of suit, and several others, I think, as well, are more in his shoes. There are mechanisms, regulations that the agency has for reopening the administrative proceedings, also for excusing missed deadlines. And the plaintiffs would have to apply. They claim that they fell within the regulations, and it's very fact dependent. So one could not speak to whether any of them would qualify, but those would be paths that would be open to them. But as I said, for many of them, I think I counted in the administrative record, perhaps 2/3 of the people in the administrative record, their last contact with the agency was before 2010. So 6 years before.
If I'm receiving today a pension that's unlawfully low because of an over elimination of offsetting of a foreign pension against my Social Security payment. I'm still receiving it today erroneously. I can't go back to the agency and say, it's only come to my attention now that this is unlawfully low, and at least going forward from now on, I'd like it to be corrected. Is that not an available, timely administrative course for a person to take?
I think one that seems to me, Your Honor, would fall within a request for reopening. And you would give your reasons why. I can't state with any certainty whether those are grounds that are permitted by the regulation. I would point the court to City of New York, where the court said that there were a number of people who I think were erroneously included in the class, whose claims had lapsed. And the court said that its ruling was not going to apply to them. So if you let your claims lapse, you do not pursue the administrative process. Generally, even in a class action, you're not part of the class that gets relief. There is some onus on the individual, Your Honor.
Indeed, as I go back to the initial determination, counsel, at the tab of 217, I see we have enclosed a pamphlet, Your Payments While You Are Outside the U.S. It tells you what must be reported and how to report. So that is, of course, why you described the initial stage as not including any of that information.
And in fact, Your Honor,
So,
all along, there has been information available in the regulations. The agency's regulations on the windfall provision were published in 1987, and there's been information online for as long as the agency has been online. So it is not, this information is not hidden from individuals. It is provided to them.
but is there in general a Hobbs Act type 60-day period for appeal?
There is a 60-day provision that the individual has to appeal after receiving the final decision. That's in section 405.
After getting a final decision.
Right, but if the court were to judicially waive some steps, or the secretary were to waive completion of some steps, you would still have to file within 60 days
Of the court's decision.
Right.
And how about an administrative timeline? What's the, from, for example, an initial determination? If you get an initial determination and you are trusting soul and think that the government must have gotten it right, as omniscient as we all know the government to be about affairs, domestic and foreign, then later you realize by reading news of Mr. Bruce and his colleagues' cases that maybe you have an issue.
Well,
you'd have to move to reopen your case. If what's the basic time limitation on between initial determination and when you'd have to question it?
Well, on page 217, which Judge Ginsburg has just referred us to, it says you have 60 days to ask for an appeal.
Got it. I see it.
I don't know if that is if it is 60 days at each point. So then 60 days after the reconsideration decision to ask for an ALJ hearing. I think every single time the claimant receives a communication from the agency, it's going to tell you exactly how much time you have and what you need to do in order to take that further step. That's part of it.
Is there anything in what's sent after the initial determination that describes the kind of more what I referred to before as the more granular issues about kinds of foreign payments that might or might not have appropriately been taken into account? Or is that something there is?
Do
they get the 2-pager on the windfall elimination provision or anything like that?
I apologize, Your Honor. I misunderstood. I took your question to mean, do they receive anything further from the agency in the form of the agency decision? And the reconsideration decision will often go into more detail on things.
No, I was just saying, because the onus is on the recipient to realize that the initial determination is really a very rough cut, given that the agency doesn't have the information on the foreign income unless and until the recipient provides it. Is there anything that's routinely given to someone after the initial determination that alerts them to that fact? Hey, by the way, this is a rough cut. We don't have anything more on your foreign income than what you tell us. And here are some of the issues that you might want to take up. Nothing like that.
As it tells you what must be reported and how to report.
Yeah, that's,
Where are you looking, Doug, on
217,
217?
the very top.
Your payments while you were outside the United States.
In the next sentence, yeah.
Yeah, so we don't have that, but we could presumably look it up.
right. Like I said, Your Honor, I mean, the regulations and the manual provisions are included in the addendum to our brief. They provide a pretty, as you said, Your Honor, the term granular description of all the kinds of information that's relevant. And then they are fairly easy to look up online. And they go through all the different steps, as I attempted to do with Mr. Pezos's case, all the different ways in which, you know, the different distinctions between different kinds of foreign social security payments and what is relevant and, you know, for purposes of the windfall provision and what takes it out of the realm of triggering the windfall provision at all. So there is a lot of information out there.
This is 32 pages, but I gather it's not one document. No, this is assembled from different documents or different
Yes.
portions of the POMS. Pardon me.
Yes, Your Honor.
At least half of it is.
If Your Honor would like, I can certainly ask the agency if there is anything that is routinely sent.
Well, we see this, it appears that it is this pamphlet about payments. Well, your payments while you are outside. I think actually this goes to sending payments overseas, actually. This is a different issue. So this goes to, you know, if you're living overseas and you want us to send you your Social Security payments as a result of the initial determination, we can't send them to you if you live in Cuba or North Korea. You know, we can't send them if you're in Azerbaijan. So it's actually quite a different question. Although this is the kind of thing I'm looking for, is whether there's any reason for the trusting soul who has an initial determination to realize what a rough cut that is, or before the initial determination, if there's any routine way that the Social Security Administration tells people before intake or at intake, look, if you got foreign income, here's the questionnaire of the kinds of things we need to know. You know, is the foreign pension because you live there, or is it because you work there? Is it because you work there for a private employer? Did you pay Social Security taxes in the US on your foreign income? That kind of thing. Like, obviously that's what's eventually needed in the administrative process. And I just wonder when that's elicited.
I think that information does come out throughout the administrative process. Again, there are many opportunities for questioning. If you read through any of the ALJ hearings, you'll see that a lot of times the ALJs will question the claimants quite closely and generally to elicit information that ends up being to their benefit. So that kind of information can come out there. If Your Honor would like for me to find out from the agency, I can do that and send a letter to the court. But I think this court does not necessarily need that information to affirm the decision of the district court.
Right.
Starting
It's all about trying to understand how the administrative process interacts with the claims here.
Right. It is conceived to be, you know, a multi-step process that is highly interactive and highly collaborative and non-adversarial with the claimant. Claimants generally do not like having their benefits reduced, and they generally do question, and they do take their appeals. That has not been a problem. It's not like there's no dearth of appeals going on.
And this Mr. Pezos, this is the result of the initial determination, this JA 215.
Yes, Your Honor, that is the only document for him in the record.
Right. And that's the result of the initial determination. So they do have an alert at the bottom of 215. It's a different citation, but to the windfall elimination provision at the top of 216 to learn more about why we reduce. So we did reduce based on your foreign income, and to learn more about why there's a site there.
Right. So it actually does not say that it's reduced based on foreign income, just to clarify. It says it's reduced based on your receipt of a pension based on work not covered by Social Security taxes, because the windfall provision also applies to individuals
Right.
who work their entire time in this country. I want to be sure and
Or
address.
not covered by Social Security. Yep.
Yes, Your Honor.
Helpful.
Including federal civil servants and
Yeah.
state and local employees,
Yeah. That's helpful.
firefighters and police officers.
Railroad workers.
Beg your pardon?
Railroad workers.
Yes, Your Honor. There are quite a number of exceptions, and that's why we want to make sure, the agency wants to make sure that if people are entitled to an exception, that they get the benefit of it. But you can't give them the benefit of it if you don't have any information on them.
So a remand in this case, which is what the parties asked for, would be a remand to make a proceed to continue further on the basis of an administrative record that is devoid of really relevant information.
That is correct, Your Honor. I mean, on the part of Mr. Jones, there is nothing.
Okay.
So I want to make sure and answer any questions that the court may have, but I've run way past my time. I apologize. And
We have a habit of doing that.
No need to apologize. You're just answering our questions.
Well, if there are no further questions, I would ask the court to affirm the decision of the district court.
Thank you. So I believe we ran through Mr. Bruce's time, but we will give you, Mr. Bruce, a couple of minutes for rebuttal. I did have one question, which is, am I right to think that your clients are proceeding through the administrative process even while they're seeking to bring this case in federal court? We don't have a group of people here who have foregone the administrative process altogether, do we?
Some of them have had ongoing cases during the pendency of this case. Plaintiff William Tran.
And I'm aware of that case. How about generally the other plaintiffs?
Well, no, Your Honor, because they're outside the 60-day window. And those plaintiffs, by the way, had no idea that there was a possibility of being able to successfully appeal this case. So when counsel claims with reference to nothing in the record that there's no problem with bringing appeals and that they do it all the time and that the agency welcomes that, that is not supported by the actual declarations that are in the record, that in fact these that there was no understanding at all that there was any possibility of prevailing in this agency policy. But beyond that, Your Honor, I would state that the counsel's characterization of the appellate process in the agency as being itself simply identical to the initial fact-building process is wrong. There is no support for that in the law, in fact, or in logic. One need only look at the initial documents that are uniform sent to every single plaintiff in the record, which they say, well, the very first communication they get from the agency says, you receive a non-covered pension, you are subject to a reduction, you have 60 days to appeal. Of course, an agency's appellate body will look into fact whatsoever, because it doesn't exist, that this process is merely provisional. And as we go along, we are going to actually determine at the very end, possibly if this windfall elimination provision is applicable to you. And it may not be. No. We need only look at the record to see that the opposite is true.
Well, I think the implication of the government's position here is that if you picked a plaintiff who was timely within the administrative process, who raised each of the types of claims that you're raising here, like, you know, is this employment within the meaning of Section 410 or not? And that person went through the administrative process, and then that person could be the impact plaintiff and a challenge to that provision, and you could get your legal determination from a district court and a court of appeals. And so I guess the question really is, why isn't that the way to tee up the issue?
Your Honor, I think that we're deviating from the standard the circuit gives us. Has the agency adopted a policy or practice of general applicability contrary to the law?
But let me put it this way. You need a plaintiff with standing. And we don't know whether the plaintiffs that you represent are or are not potentially benefited by the reading of, for example, the definition of employment in 410 that you advocate, in contrast to the reading that the government has adopted. And unless we know that the facts of your client's case are such that would implicate the provisions that you're seeking to challenge, that person doesn't have standing and we couldn't hear the case.
Your
Why
Honor,
isn't that an additional reason why exhaustion is necessary here?
it is beyond question that they are subject to the windfall elimination provision. And we
Well, as a general matter, but the specific things that you're trying to challenge.
Mhm. Right. They are subject to it only by means of a single binary policy applied from the beginning, which exists in the Palms and says that if you do not satisfy any of the exemption criteria, then you are subject to the general policy. The fact that there are foreign plaintiffs who may not have been able to provide certain documents is not to turn the presumption under Rule 56 on its head and construe that fact in the light most favorable to the moving party as opposed to the non-moving party, Your Honor. We know by looking at the agency's own statements why anyone in those shoes has been subject to that policy. And it is because they have been deemed to be recipients of non-covered wages, which you can locate within the policy. Your Honor, counsel pointed to the fact that there were actually some recipients of foreign pensions who won in the agency process, and this somehow supports their argument. I think it's useful to look at how those ALJs in the record actually arrived at their decisions. Had nothing to do with any of these irrelevant agency criteria and this supposed fact-finding process throughout the reconsideration progress that in fact does not exist. No, those ALJs simply looked at the governing law and they looked at the policy and they said, no. I mean, the agency just said no to the policy. It violates the governing law. We have a situation, this indicates, this is perhaps the best indication that we're not even talking about an orderly agency process. We have governing law saying do one thing. We have the agency doing another thing. And
do my colleagues have any further questions?
No, thank you.
All right. Thank you, Mr. Bruce. We'll take the case under advisement.
Thank you.
Case number 20-1471, Inteliquent Inc. Petitioner versus Federal Communications Commission and United States of America. Mr. King for the petitioner, Ms. Citrin for the respondents, Mr. Horvitz, amicus curiae.
Good morning. Good morning, Mr. King, Ms. Citrin, Mr. Horvitz. Mr. King, we'll hear from you first whenever you're ready.
Morning, Your Honors. May it please the court, Kevin King for petitioner Inteliquent. Your Honors, this case is very different than the preceding one. This one concerns the FCC's toll-free calling order, and in particular, the 1/10 of a cent per minute rate cap imposed by that order. Your Honors, we would submit that the rate cap should be set aside because the FCC failed to comply with the APA's requirement of reasoned decision-making. And I'd like to focus on two aspects of that problem today in particular. First, the FCC's arbitrary and inconsistent treatment of the rate data submitted by Inteliquent. And second, the FCC's near total deference to a deal struck by US Telecom's large, well-connected member companies.
Isn't the case that neither set of data is really complete or representative, neither Inteliquent's nor US Telecom's?
Yeah, with respect to costs, I would concede that neither of them gives a direct, clear picture of current costs for tandem services. And for that reason, we think that there's a historical linkage between our data and costs, but I'd prefer today, with the court's indulgence, to focus on our arguments about rates and why they're relevant. And one of the reasons I want to do that is the studies submitted by Inteliquent and US Telecom spoke to the same basic thing. The national average for current rates charged for tandem services. You've got apples and apples between those two. And yet, nevertheless, the FCC treated them inconsistently, right? The FCC's approach, adopting US Telecom's proposal while dismissing similarly situated conflicting evidence submitted by Inteliquent, was arbitrary and capricious. That's really our first argument here today. Our model showed a nationwide average rate of 1.7 tenths of a cent per minute based on a broad and comprehensive data set consisting of more than 3 billion call minutes per month, the vast majority of which were drawn from jurisdictions served by low-cost providers. As T-Mobile said in its comments, Inteliquent's model provided a reliable nationwide profile of toll-free calling traffic.
King, could you maybe just explain a bit what you expected the FCC to do here? So you can see that there is no reliable cost data on either side, and you suggest you need the 1.7 of a cent as opposed to the rate that they adopted. But how was the FCC supposed to choose between the two of them? Did you expect them to pick a midpoint? What did you exactly want them to do with your proposed rate as opposed to US Telecom's proposed rate?
Sure. Two responses, Judge Rao. I do want to clarify what I said earlier. We do think that there is a historical linkage, not a perfect direct one, but we do think that our rate data did shed some light on costs and that the agency should have taken that into account in some fashion. But so again, setting that aside and focusing just on what the agency should have done with respect to current rates, our point is not really that the FCC should have been constrained in picking our rate or US Telecom's. We're not here today arguing that the FCC was compelled to select our proposed 1.7 cent per minute rate. Instead, what we think the FCC needed to do was treat our data consistently with US Telecom's, since they both spoke to the same exact topic, an average of current rates. And it needed to give a reasoned explanation. If it's going to choose US Telecom's proposal, 0.1 cent per minute, it needed to explain why that proposal better served the order's goals than ours did. It needed to compare the two and work with them. As this court said in the Genuine Parts case, and as this court said in Business Roundtable, Judge Ginsburg, a decision that you authored, the agency has a duty to address conflicting data. We're not really saying what they needed to do after they addressed that conflicting data. We're simply arguing that they needed to address it.
Isn't a central aspect of your challenge, though, that the rate that was set doesn't adequately take into account cost, but you never provided the commission with any data about the specific cost for your services, for Inteliquent services, did you?
We did not. And so, the sort of the narrow point there, we would concede. We never provided Inteliquent's cost data to the court.
So we don't actually know whether today, I mean, I know that you have a tariff and that there's an implication there that, a higher rate was approved and the tariff is still valid. But one of the responses I take the commission to have made to that was, yeah, it's still a valid tariff, but costs have actually really reduced radically over time. And so it's really not reasonable. I know there's a little bit of sparring back and forth in the briefing, but it's not really reasonable to think that costs, in fact, are as high as they were when that tariff was set.
Well, I mean, the tariffs were the price caps were initially set in 1990 based on actual costs. And then the FCC made periodic downward adjustments to account for efficiency gains. And you can have a debate about, sort of how reliable, current price caps are in terms of reflecting, current costs. There, in our view, there is some relationship there. You can debate how strong it is. But again, even if you credit entirely the FCC's cost concerns, the order is still arbitrary and capricious because it doesn't give a reasoned explanation for treating our data differently than US Telecom's. Both of them spoke to the same issue, yet the FCC adopted US Telecom's and brushed ours aside, even though the costs objection that the FCC raised with respect to our data applies equally to US Telecom's data, right?
I don't know if this is you could flip that and say, you're advocating the commission shouldn't base a national rate on any one provider's data, but you're basically saying, well, they should have relied on ours, which would have been subject under your theory to the exact same challenge from US Telecom. So what would have been your defense had the commission embraced your data and not US Telecom?
Well, I think I'm trying to think this through. If the agency had embraced our data after comparing the two and considering both of them and not just sort of brushing one off on an irrelevant, inconsistent ground and sort of, gone through the paces and explained which of them better serves the order's various objectives, I don't know what our defense would have been. But again, that's not what the agency did here. The agency brushed ours aside on cost grounds that apply equally to both data sets, and then proceeded to, without really any further reference to ours, just to adopt wholesale US Telecom's proposal.
Didn't the FCC in part suggest that the Inteliquent proposal would better prevent arbitrage for toll-free numbers, right? And was there any evidence that your rate would have the same impact?
I don't think, as to your first question, Judge Rao, I don't think there's anywhere in the order, and we've spent a lot of time with this order, as I'm sure you and your clerks have. There's nowhere in there where the FCC says US Telecom's proposal is going to better deter arbitrage than Inteliquent's. They never get to that.
Well, Mr. King, the point was, though, that any lower price would reduce arbitrage because the opportunities for arbitrage would be reduced.
Yeah, and so our rate, Your Honor, our proposal, which we're not arguing the FCC was required to accept, but ours would be, a nationwide weighted average, right? So half the rates out there in the world would be above it and would need to come down. So there would be substantial reduction.
But you say it's a nationwide weighted average, but it's based only on your data. Right. You talk about the very large, billion data points, but it's only, again, like US Telecom, it's only a subset of the market, right? A nationwide, but nonetheless subset.
Well, I guess I'd resist that a little bit, Your Honor, because for a few reasons. One of them is the FCC's benchmarking rule, right? When a competitive provider provides tandem service under the benchmarking requirement, it must peg its rates to the local incumbents, right? And so the rate cap for a competitive provider is going to be tied to that, that local incumbent. And so, Inteliquent provides service nationwide, 49 states. So we're benchmarking our rates to a wide range of different incumbents, which means our data is nationwide and it takes into account not just large providers, which is what US Telecom looked at exclusively, but also data from smaller providers.
That's a really nice point. And that's in your comments in the record? Where is that in the record?
It is. If you look at page, I believe it's 92 of the record, footnote 5, but let me verify that for you. Yeah, that's right. JA 92. Footnote 3, we explain that the 10 miles of transit, and I'm sorry, one other citation for you on that. JA 268, footnote 5, we explained that we take into account data from areas served by smaller providers. So you do have this difference, right? Our data is a weighted national average. US Telecom's is an unweighted survey only of areas served by large providers. And we don't even really know which large providers US Telecom surveyed, right?
US Telecom has both large and small members. So how do we know that they surveyed only their large members?
We know for a few reasons, Judge Ginsburg. One is that that's what they said. They represented.
Their second letter, they said that they had a unanimous approval from their membership for the 1 cent proposal.
They have unanimous approval from their membership. I don't think the record discloses what their membership is, but the 1/10 of a cent per minute calculation is by its terms the approximate midpoint of the rates currently charged by US Telecom's larger members. That's what the FCC said in the order. That's what
But apparently the smaller members are happy enough to live with it, right?
It appears so, but I guess, Your Honor, what I'd say in response to that, and if you look at the Fifth Circuit's decision in Texas office, which draws on reasoning from this court's precedent, even unanimous agreement among industry stakeholders is not sufficient. Agencies are not permitted to cede near total deference to those kinds of agreements. And here, the agreement among the industry was not unanimous, right? You had a number of providers, including Inteliquent, T-Mobile, Peerless, and others who were challenging US Telecom's approach. And so, Judge Pillar, just to come back to something you were saying, and I think Judge Rao, you were raising this as well, is there evidence that Inteliquent's proposal would have well served the order's goal of deterring arbitrage? Yes. We supported that goal. We supported a rate cap to deter arbitrage. And if you look at our comments, I think at 92 to 96, and also T-Mobile's comments, a disinterested third party at JA 275, they say that our approach would be well equipped to deter fraud and abuse. So you had record evidence that was conflicting with the conclusion the agency reached, and yet the agency brushed that evidence aside on irrelevant, arbitrary, selective grounds. And that really...
There were rates out there that were in excess of, I believe, 4 cents in some cases, correct? So any rate below that will remove some opportunities for arbitrage. As I understand the agency's intention here in their order, they set out to do something as soon as they could to reduce arbitrage on an interim basis, because they are ultimately going to revisit this and devise some kind of bill and keep or other system. So this is saying, well, look, what can we do in the interim that will be quick and dirty, right? And here's our explanation. These people have agreed that this would work at 1 cent. We got a few outliers here who are complaining about 1 cent. Well, they can seek a waiver if they can make a cost showing that 1 cent doesn't recover all their costs. Sounds like a perfectly reasonable way to get a way station, to get to ultimately toward their goal.
Your Honor, a few responses to that. I'll start with the outliers point. There's no data in the record to show that the carriers, I think it's Orion and another one, are necessarily outliers. Again, we've got the data which the FCC hasn't challenged.
If they're getting more in excess of 4 cents and they're identified as being on the very high end of the spectrum, right?
Yeah, I think our point is that Inteliquent did this sort of broad nationwide study, and we showed a weighted national average of 0.17 cents per minute. And so you've got half the rates are they're out there in the world are going to be above that,
It's
according
based
to our
on
study.
your experience and your study, based on your own data. And so even if it were, let's assume that your study is superior in all relevant respects in terms of accurately reflecting what costs?
No, rates, right? We're talking here about what are the rates out there in the
We're
world.
setting a price cap. The agency's setting a price cap. They're not interested in rates. They're interested in costs.
On the contrary, Your Honor, the order says they're not looking at costs. It says they're just looking at rates. And again, they adopted lock, stock, and barrel US Telecom's proposal, which was the approximate midpoint of current larger providers' current rates. So if that's the right metric, our submission.
I misspoke there. They're looking at rates and trying to set a rate that is untethered to costs and that they know all of the large portion of the industry, indeed, the great majority of it can live with that, is not unhappy with that. And they know that there are a few people who are not going to be happy with that.
Well, again, I guess two responses, Your Honor. First is that under the Texas office case, which is from the Fifth Circuit, but relies on this court's precedent, the fact that some people, some part of the industry is happy with the rate is not an adequate basis to adopt that rate, especially when there's competing, equally situated data showing that rate is not representative.
Go ahead.
I think the point of that in the case there, if I remember correctly, was that the agency can't just rely on the waiver process, and say, well, we don't really know how many people are this won't really work for them, but they can rely on the waiver case. Here, the agency knows that it does work for the vast majority of the industry.
Well, Your Honor, I guess, again, our challenge, and you don't have to take it from us, you can take it from T-Mobile at JA 275, is that it doesn't work for the vast majority of the industry and that US Telecom's approach would not better serve the order's objectives. All we're asking for here is a pretty narrow move on the FCC's part to analyze our data, in the rate making analysis, to factor it into that analysis on equal terms with US Telecoms. They don't have to adopt ours. All they have to do is give a reasoned explanation for why one is better than the other. That reasoned explanation is nowhere in the record. And so this case really is on all fours with genuine parts where the agency overlooked relevant conflicting data. And what this court said is you can't do that, right? The FCC invokes rate-making deference and cases about predictive judgments, but the error here doesn't implicate those precedents. Our challenge focuses on the decision-making process that led to selection of the rate cap and not the accuracy of the rate cap itself.
So, Mr. King, I understand the sort of framing that you just gave, but is the underlying concern that the rate that the FCC chose would not cover costs for providers of tandem services, especially those that aren't diversified and so can't kind of internally cross-subsidize? Is that the core sort of fairness concern, if you will?
I think that's a big part. I don't think it's the only part. I think, there's a concern here that there was a backroom deal put together by US Telecom's large members, and they went and presented it, and the FCC just sort of took it hook, line, and sinker and then backfilled the legal analysis. And so we're concerned about that too. We're concerned about process as much as we are substance. But yes, there's a concern that, for providers who, have this legacy service, the so-called TDM service, not the IP modern service, that, it's going to undercut them in a really meaningful, problematic way. And again, I keep coming back to T-Mobile. If you look at 275 in the appendix, you'll see they say taking US Telecom's approach is going to slow down progress in terms of transitioning to IP networks, because providers like Inteliquent help facilitate that process. Competition helps facilitate that process. But here, what US Telecom's powerful members are doing is undercutting that competition.
And I understand that your primary point is that explanation should have been fuller with respect to the choice of US Telecom's data versus your data. But is there evidence in the record of providers of tandem services, TDM providers, that whose costs won't be covered and who aren't diversified in a way that allows them to survive this? Or is that just sort of in the background of the data?
I think there is some evidence of that nature in the record, and I would point in particular to a company called Orion, A-U-R-E.
Right. We've seen, so Orion is what you'd point to?
I think that's the best example. I'm not sure it's the only example. I'd be glad to file a 28J if you'd like to hear more on that issue.
No, I think with the Orion letters, plenty. Do my colleagues have further questions?
No, thank you.
All right. Well, Mr. King, we will give you, as is customary, even though we've run you out of your time, we'll give you some time for rebuttal. And now we'll hear from Ms. Citron for the commission.
Good morning, Your Honors. Sarah Citron for the FCC in the United States. I think that the discussion that's come before really illustrates how narrow the dispute is in this case. We agree about a lot of things, and I think that the questions from Your Honors indicate that you understand the commission's position quite well. There was no evidence in the record on current costs of providing these services. The FCC didn't have that to go on. And there was also no dispute, or at least Inteliquent doesn't dispute, that arbitrage was a real problem that the commission reasonably sought to address, and that other things being equal, by which I mean two rates that were both adequately compensatory, as between two rates of that nature, as Judge Ginsburg said, the lower rate would better serve the commission's policy goal of deterring arbitrage. So the question really becomes, did the commission have substantial evidence to conclude that the proposed rate cap from US Telecom would be adequately compensatory for all or nearly all carriers? And I'd like to
I guess the nub of what I take to be behind Mr. King's challenge is, how does the commission know that each of these rates is, as you put it, adequately compensatory? Because I think everyone agrees that there wasn't systematic cost data in this record. And if it's your burden as the rulemaker to come up with a rule that's non-arbitrary, why is that not a flaw?
Yes, Your Honor, the commission, I think it's clear from the order, a number of different considerations that the commission took into account that led it to conclude that this rate was adequately compensatory. One of those, if you look at JA 367, footnote 216, there were a number of existing tariffed rates that were already at or below this level, this 0.001 level. And in addition, there was no evidence in the record. Inteliquent doesn't even make the claim, and didn't make the claim before the commission. It doesn't make the claim here that it couldn't recover its costs. The commission pointed out at footnote 375, I believe, that the supporting amici here, although they made that claim, they presented no data to substantiate it before the commission. Similarly, the ACAM Broadband Commission or Association that's referenced in the briefs, they didn't present data to show that their costs were higher. So the commission had nothing that that would lead it to think that there were higher costs. And in addition, it had from US Telecom in a number of different pleadings, including a May 2020 letter, a June 2020 letter, the US Telecom's initial rate cap proposal. In all of those pleadings, US Telecom told the commission that this rate would be sufficient to allow carriers to recover legitimate costs.
What about in footnote? I mean, maybe your position is that yes, there will be some providers with far above average costs, and they're just, that's a competitive environment. They're going to be out of luck. Is that part of your position? It doesn't matter if some approved tariffed providers will not be able to recover.
No, Your Honor, that's not our position. The commission recognized it at paragraph 115 of the order, I think, that the rate should be adequately compensatory, but it had reason on this imperfect record, it had enough. It believed and reasonably believed that this proposed rate would be adequately compensatory.
And is that because so for a provider like Orion, as you were referring to in footnote 375, they say, well, we sort of have put cost information before the commission because the cost study that justified our tariffed rate, which was, I gather, 4 cents, was the basis for the approval. So they're saying, this is really cutting us off at the knees. And then, as you point out in paragraph 115, you say each carrier will have the opportunity to recover its costs. And what is the assumption that a carrier like Orion in the intervening period has gone more to IP rather than TDM, and therefore its costs are actually radically lower as a practical matter, or is there something else going on?
That might well be the case, Your Honor, but I think the other piece of this, and some of the earlier questioning alluded to this, is that the fact that a rate is deemed lawful under the commission's tariffing system doesn't necessarily include a robust analysis of costs. I'll agree that Orion's cost data is the only evidence in this record at all concerning any carrier's costs. But the commission, I think, reasonably anticipated that that was an outlier in light of these many, many much lower rates. And of course, Inteliquent's proposed rate cap wouldn't have allowed Orion to recover its claimed costs either. So I think even Inteliquent can't reasonably contend that Orion's costs should have been the basis for the commission's chosen rate cap. A reasonable rate cap need account for the costs of the individual costs of every provider in the market. What the commission had to do was consider, was this rate likely to be good enough for the vast majority of providers? And for the reasons I was articulating, the commission and a few others I can get to, but the commission thought it was. And if there is, and I don't concede that this is the case with Orion, because that's not the way the commission's tariffing system works, that Orion's claimed costs should be taken as proved. But Orion would have the opportunity if its costs were unusually high. And my understanding is Orion is kind of a uniquely situated provider in the way that it has set up its network, but it could come to the commission and seek a waiver if this rate cap wasn't adequately compensatory. That's not relying on the waiver to justify the reasonableness of the rate cap.
Yeah, that is a question I had. I mean, is the agency relying on the availability of waivers to justify the reasonableness? I mean, you're saying that it's not relying on that availability.
No, Your Honor. Well, I think what the agency has to determine and explain why it has determined is that this rate cap is likely to be adequately compensatory for everyone or almost everyone, and that if there is some exception, some unanticipated exception to that general rule, that there is a backstop mechanism available, and that's all the waiver is. I'd like to.
The backstop can't be a reason why a general rule is reasonable or a general rate is reasonable, can it?
That's correct, Your Honor, but I think it does address I think this court has looked in other cases to the backstop as a means. If there I believe the case is WOCO Radio. I may not have the call sign quite correct, but the agency, it won't always be possible for the agency to account for every last possible outlier in setting a general rule. And if there is some exception and the agency has in place a mechanism to accommodate the possibility of such exceptions, that does support the reasonableness of the rule, so long as the rule.
So you are relying on the availability of a waiver as one of your arguments for the general rate to be reasonable. I mean, that argument strikes me as pretty difficult, frankly, for the agency.
The rate is reasonable, even if there were no waiver mechanism here. I think the agency would have adequately justified the compensatory nature of this rate cap, because, as I said, Orion's claimed costs have not been proven. They were the only claim of any costs by any provider that were higher than the proposed rate cap. And in that context, I don't think the agency reasonably needed to set its rate cap based on that claim. And in fact, Inteliquent doesn't think the agency reasonably needed to do that either, since its own proposed rate cap wouldn't have accounted for that. Again, the agency had here, what did it have to let it, what are we relying on to support the conclusion that this rate cap was reasonable? We have many instances of much lower rate caps in that footnote. By the way, many of those carriers, I might mention, I think all of them referenced in footnote 216 do not have long distance businesses. So these are not the kinds of carriers that could be accused of cross-subsidizing by paying lower rates as long distance providers. We have representations from US Telecom that this was an above cost rate. We have, as Judge Ginsburg was pointing out, the varied membership of US Telecom, large carriers, small carriers, rural rate of return carriers, carriers that own tandem switches. All of those carriers agreed that they could continue to provide service within this rate cap. And we have no evidence from anyone else that they couldn't. We have no current cost data, as Inteliquent agrees here today. And we have, in addition, a carrier bandwidth that was not a member of US Telecom that also supported the rate cap.
Ms. Citrin, is the commission obliged by law, or is it its consistent policy to make sure that a rate cap accommodates every regulated firm?
Not every regulated firm, Your Honor.
So the rate cap, assume there's no waiver provision. If there's some companies that cannot function under the rate cap, they simply lose out.
I think that's right.
Oh, okay, this is, you're trying to move the industry towards VoIP, and there's going to be some legacy carriers, just as there were with airlines and with every other industry that either was deregulated and had a rate cap set by competition or a rate cap set by a commission. There are going to be some who cannot adapt to the next technology.
That's right, Your Honor. And I just add that on this record, there's no evidence that would be many. And in fact, no carrier has sought a waiver.
But it's just, you're not obliged to set a rate that will cover every regulated firm.
That's right, Your Honor.
Yeah, I thought the scheme was to benefit consumers, actually.
Yes, no, I think that gets it just right. And so for all of those reasons, if there are no further questions from the court, I'd ask that the petition for review be denied.
Thank you, Ms. Citrin. And now we'll hear from Mr. Horvitz for US Telecom.
Thank you, Your Honors, and may it please the court. Kevin Horvitz on behalf of US Telecom. The FCC was right to conclude that US Telecom's proposed rate cap was likely to reduce the incentive to make artificial toll-free calls, while also providing sufficient compensation for telephone companies that offer legitimate services. I'd like to address just 2 points that the court has asked about here today. First, as the FCC noted, US Telecom's proposal was a consensus proposal on behalf of all of its members, not just a few large ones. That coalition of companies includes both incumbent and competitive providers of all sizes. That's in the record. It's right in the first sentence of US Telecom's proposal at JA 249 and at JA 259. And all of those members agreed that the rate was adequately compensatory and would serve as a meaningful deterrent to artificial toll-free calls. That includes companies, many members that only provide tandem services on toll-free calls and do not purchase them, that could not conceivably profit from a below-cost rate for tandem services. And the second point I'd like to touch on is that the Commission's rationale for selecting a rate that would be.
Do you have a cite for, I'm sorry, do you have a cite for that last point that it includes many who only provide tandem services? Is there anything in the record that allows us to know that?
Yes, there are a few things. Windstream's August 5th, 2020 ex parte at 3 is making a representation on behalf of Frontier and Windstream, and it says, because neither Frontier nor Windstream sells retail inter-exchange services, the companies would not enjoy any offsetting reduction in payment of access charges.
And you're at JA.
By wide traffic.
You're at JA.
It's not in the joint appendix, but it is in the record that is part of the proceeding. It wasn't, that specific citation was not cited in the briefs, but it is because it was an undisputed proposition. US Telecom includes many other members that do not sell retail inter-exchange services as well, including small rural carriers as well. So I want to just
your second point. I'm sorry, I interrupted you. You had a first point that it was a consensus proposal, and then you were going to move on to a second point.
Yes, the second point is that the Commission's rationale for selecting a rate that would be a better deterrent to artificial calls is explained in a lot of detail earlier in the order, and that's paragraphs 16 through 44 and 55, when they discuss the need to transition end office charges to bill and keep. And the Commission explains that if they were to transition end office charges without lowering tandem rates, based on its past experience, that would be likely just to fuel arbitrage with respect to tandem calls. And so the rate Inteliquent proposed was not designed to deter that arbitrage. It was simply designed to ensure that it would not lose revenues. So if the court has no questions, we ask the court to deny the petition for review.
My colleagues have further questions?
I take it, Mr. Horvitz, that going to your point about deterring arbitrage, that arbitrage is more reduced to the extent the rate is reduced. Is that correct?
Yes, that's absolutely right. It's just a matter of simple economics. The lower the rate is, the less room for arbitrage.
Any reason to think that the 1 cent will eliminate all arbitrage?
I think that it will have a significant effect in deterring arbitrage. I think any rate that is above cost, there's always some possibility.
Providers will not be commercially feasible?
No, I think that there are different compensation systems that could work to allow tandem providers to recover their costs of providing service, and that could be the commercial arrangements with long distance carrier or with the party that is sending them the traffic currently. And also,
is that, I guess I'm just asking, is that sort of what's going on here? Is that eventually these services are going to become obsolete? Is that part of the concern here?
I don't think necessarily they'll be obsolete, but during the transition to IP networks, I do think that these services are becoming less relied on.
But, and isn't at the end of the day, I mean, there still will need to be some kind of service, or everybody can just do it themselves? I thought the assumption was that the different providers in the chain would just have to contract with one another rather than do a rate-based business model.
Right. So I think that both situations could occur. I think that there could be commercial arrangements to the extent that they are continuing to rely on this intermediary player. But I also think with the transition to IP networks, you could basically skip the intermediary entirely and route directly to the long distance carrier.
Thank you.
Other questions from my colleagues?
No, thank you.
All right, thank you, Mr. Horvitz. And Mr. King, we reserved a couple of minutes for you for rebuttal, and proceed when you're ready.
Thank you, Your Honor. I'll start with the just sort of factual question on what service Inteliquent provides and other companies like Inteliquent provide. They provide a mix of legacy TDM service and IP service. And really the mainstay of what they do is they convert one to the other and ship it on to the rest of the network. There are a wide range of providers like wireless companies like T-Mobile, for example, and small rural carriers whose network is set up in TDM. That's how they operate. They don't have their own facilities to do IP. And so where companies like Inteliquent come in is they make that conversion. They get the traffic into the modern IP format and send it on to the rest of the network. So
if the traffic's going the other way, how do they need you still to step it down into non-IP signals?
Correct. Yeah. To get a call to a wireless, you need to step it down, is my understanding. And so, contrary to what Mr. Horvitz said, you can't just take the converters out of the process. The network wouldn't function in that scenario.
Are there places in the country that just rely on TDM? I assume there are, or not.
I think I'd rather not speculate on that. My understanding is that there are sort of small rural carriers where everything is in TDM, but I'm not 100% sure on that. And then again, the wireless providers, a lot of them don't have, their network's not entirely IP. So that's the factual scenario. Let me go to the sort of the legal point, and Judge Ginsburg, from what you were saying, the FCC's order does not say lower is better, and therefore US Telecom's proposal is better than Inteliquent's. That might be a rationale that they could give on remand, but that's not the rationale in the order. Why? Because the order arbitrarily dismissed Inteliquent's data on cost grounds and never really grappled with it when looking at current rates. All we're asking for here is for the FCC to treat our data, which is situated similarly to US Telecom's, in an equal, even-handed manner, and to consider them both as this court's precedents require. So that explanation is not there. Maybe it's one they could give. As far as what model would better serve consumers, I agree that that's the metric here. But again, there's no finding from the commission that US Telecoms would better serve consumers, or just that lower is better. Lower from a consumer standpoint is not better, because if you go too low, you're going to drive out the competition that's necessary to drive down the rates. The introduction of competitive carriers like Inteliquent here has driven down those rates because there's competition from the incumbents that otherwise were providing this service. So there is a consumer orientation here to the procedural request that we're making. It's notable that the FCC, you just heard argument from their counsel, doesn't dispute that the order is inconsistent in its treatment of our data and US Telecoms. It's also notable, you've never heard at any point in this case from the FCC that our data presents the kinds of arbitrage concerns that motivated the order. The traffic that we're studying doesn't present those concerns.
All right.
Go ahead.
If you had just a sentence you wanted to use to wrap up, that's fine. But I think otherwise we're well over time.
I appreciate it, Your Honors. All we're asking for here is a reasoned explanation. And because the order doesn't give it, we urge that the rate cap should be set aside and the matter remanded to the FCC. Thank you, Your Honors.
Thank you all for an illuminating and well-supported set of arguments. Case is submitted.
This honorable court is now adjourned until Tuesday, November 2nd at 9:30 a.m.